All right. Welcome, everyone. Good evening. Thank you so much for joining our workshop on behalf of Decoding Dyslexia North Carolina. My name is Emily Mora, and I'm so glad you can join us either live or watching this recording. We are honored and so happy to have Rebecca Cathcart here with us. She is a law associate with Legal Aid of North Carolina and their Right to Education project. And I love the message, the goal of the Right to Education project, right? Educational justice project to fight for students' rights to quality education and to end that school to prison pipeline, which is wonderful. All of our goals, and we know that those students struggling with literacy skills are one of the groups especially vulnerable, right, for that school to prison pipeline. So thank you so much, Rebecca. I will pass it over to you. When I hear you say next, I will move the slides.
Yes, thank you so much for that introduction. And just to explain that, so I had a little trouble sharing my screen for the presentation. So Emily is graciously sharing my presentation through her screen, which means that you'll hear me go next, next, next throughout this. So I apologize for that. But good evening, everyone. I'm excited to talk with you tonight. Our topic is dispute resolution, specifically in special education matters. Handling disputes with the school is it's complicated to put it mildly. It's an emotional experience, and it's an experience where there is a steep learning curve. I am a parent myself, and I have a child with an IEP, so I've been in the parent shoes as well as in the advocate shoes. We all want our kids to thrive, and we're emotionally invested in that. Advocating for them can feel like a fight, and we're balancing that fight while also navigating relationships with staff and administrators, all in the service of doing what's best for our kids. So what do we do? How do we try to prevent a crisis situation to explode from a disagreement? How can we prevent a full-blown dispute that requires more formal actions than just conversations and communication within the school district? So we want to I'm going to carry you through that timeline of informal advocacy options through more formal advocacy options, so that we can talk about, what do we do? What do parents or guardians do when we're having a disagreement and we feel like it's heading in the wrong direction, to a tense direction? And then what do we do when we're already there? We have a dispute, our efforts to resolve disagreements informally have not worked. And maybe you think that your concerns are not being addressed adequately, and you need to take it to the next level. Next. I want to introduce you to my project, the Right to Education project, where I work within Legal Aid of North Carolina. You may or may not be familiar with Legal Aid of North Carolina. We provide free legal services in civil matters to low-income people in order to ensure equal access to justice and to remove legal barriers to economic opportunity. The Right to Education project, where I am a law associate, is the statewide, as Emily said, education justice project of Lance that fights for education justice, dealing with, our cases can range from special education claims, education discipline claims, enrollment issues, and a tangle of all those, a tangle of special education issues with discipline issues, discrimination issues. Maybe there are some bullying issues that play into our claims or our clients' experiences as well. And as Emily said, we fight for education justice and an end to the school to prison pipeline in North Carolina, but of course, more broadly. Next. And so who am I? As Emily said, I'm a law associate with REP. I have a JD. So being a law associate, that means I have a JD and I'm in the process of becoming licensed, and I work under the supervision of licensed attorneys. REP has 4 attorneys, 1 paralegal, 1 social worker, who provides more holistic support to our clients beyond just the legal issues that we're tackling, and 1 law associate. So that's me. And I'm also a parent. I'm a mother to an 8-year-old student with an IEP. And so there's my adorable daughter right there. Next. So here's our agenda. Tonight we'll talk through strategies to prevent a dispute, like I said, and problem solving steps you can take without taking formal action. We will cover formal advocacy options as well. And then I'm happy to take your questions. Next. I do want to raise an important note, which is that I'm providing general advice and strategies. So I'm not providing individual legal advice tonight. I can't answer individual case questions and give you individualized advice, but I can address these general strategies and options and rights. So my goal tonight is that I provide you with information that results in you coming away knowing what tools are in your toolbox, and feeling empowered and familiar with your options. And then also, we will share this presentation with you, these slides with you, and they're riddled with links and a little bit more in-depth information that I won't read verbatim, but that you can refer back to and get reminded of the process and of your options, and get connected with other resources online. Next. So most importantly, I want to connect you to our website. And now you can obviously use the QR code to connect. Also, the link is right there. We have done a lot of work over the past year or so to create robust resources for parents and guardians and students with education concerns, ranging between all the issues through all the issues that I mentioned: discipline, special education, discrimination, bullying concerns, enrollment concerns. And there's also we're continually adding to resources to map community organizations and advocates throughout the state that parents can connect with to grow your community and build your team, as we'll discuss a little bit later. Next. So this is what you'll see when you go on the website. When you click this link, you can scroll down and you will see these buckets, these different sections, and each section is a door to like a series of drop-down menus with questions you might be asking yourself or issues you might be facing, sort of common issues, that you can open up and see what laws apply, what are your legal rights, and some strategies that you can use to address that issue. And then also general advice about your special education rights, your students' special education rights, their rights as a general education student as well, and templates you can use for communicating with the school district, whether that be sending email requests, ranging from sharing concerns to reporting a bullying incident to referring your child for evaluation. And then also some links to school board policies and some of the resources I mentioned, where we've mapped community groups throughout the state. And you can explore that more on your own with your student. And I'm also going to be referring back to things that are on our website and sort of where they're housed on our website throughout the presentation. Next. So let's get into problem solving strategies. And in this section, I'm going to be talking about informal dispute resolution steps you can take to address a disagreement and prevent that crisis situation where you may need a formal action. Next. So as I go through this section, the preventative section, I'm going to expand on each of these advocacy tips. These are tools that you can use at school and school district level before taking a formal action by filing a complaint. And hopefully you can come to a resolution through these steps and build your toolkit of resources to use in future disagreements. There are many advantages to resolving a disagreement informally rather than getting to the point of a crisis that you need to deal with or that you feel you need to deal with a formal complaint. The resolution, for example, the informal resolution may be much faster than the resolution that you may get through the complaint process. As we'll talk about later, a formal complaint can take time to investigate. Certain types of complaints may have to go to a hearing, and that would take time and resources. Also, there's the issue of navigating relationships. Your student may be young. They may have years to go at a school. You may be just in the process of opening the lines of communication with the teachers and administrators who work with your student and counselors and the social worker at your student's school. So, or it may be a new disagreement and you want to try to resolve it before your student suffers any harm from an inappropriate or inadequate situation. So informal measures are appropriate and could be your best option in those cases. Next. I want to lay the groundwork. I want to just put this in your mind to carry with you throughout this whole presentation, which is that you are the expert on your student. And if something doesn't feel right, if you think that your student's needs are not being met, they need something different or more in school, you should speak up and reach out to teachers and IEP or 504 team members, maybe administrators or people at the district level to address it. If it's not being addressed or if you're not sure how to address it. And that doesn't mean that you immediately know what the solution is or know what the possibilities are or know what assessment your student should have or what accommodation or what type of special education service your student should have. But your gut is telling you that something's wrong. And so it's important that you follow your gut. And I know that it can feel like there's a steep learning curve and it can feel like there's a power imbalance, especially when you're at a school meeting and it's you against, a team of people from the school and they're a mishmash of experts as well as people with a lot of experience with IEPs or 504 plans and that you feel like they know more than you. So I want to encourage you to speak up and not feel intimidated. And whether or not you feel intimidated, if you feel like the situation is not being resolved, take some of these steps to push forward and continue to assert your concerns if you feel like you still have them. Next. So I'm sorry. Another thing that's important is to build your team. And so here we have a cartoon that's illustrating exactly what I just talked about. And I love their little hats. You can't really see it from this display, but their hats have the little like acronyms for all their positions. Like one's the speech therapist, one's the LEA interpreter. You may have seen that label at the bottom of your meeting paperwork, or the interpreter of instructional services, the LEA representative. And, this can feel like you're against a group of people who know what should be happening already and maybe know better than you what the situation calls for. Or even if you feel like you have a better take on your student and you know what they need, you may feel outnumbered. And so we encourage you to build your team from inside the school and from outside the school. For people who can either attend meetings with you, like literally be present in person or virtually, or who can contribute their opinions and perspectives in writing for the IEP team. You can identify people who know your student, like teachers, if you've been in touch with the social worker at school, if there's been a counselor involved in addressing your concerns, or if you want the counselor to be involved, you can ask them to be involved. And you can make sure to cultivate sharing that relationship by sharing your concerns in writing with those people and corresponding with them about what they think is appropriate for your student. And once you cultivate that relationship, that person can be someone who can be present or contribute information to the IEP team at a meeting to help them understand what your students' needs and challenges are and what are their strengths. Help the team to know your student to appropriately tailor an individualized education plan in order to provide your student with access to education and to make the opportunity to make progress at school. You can also tap people from outside the school. That these could be people who are part of your student's healthcare team, if your student, their doctor, or if they see specialists, therapists that they may see. Um, if they already have therapists in school, you might have in-school therapists on your team who can provide perspective, as well as your student's outside occupational therapist or literacy support person. I had tutor on here for a second, but I think not everyone has access to tutors, but also sometimes the tutor hat is worn by people in your family. Sometimes people in your family are heavily involved in supporting your student with their work or caretaking, and your family members can also be people who can attend IEP meetings or contribute information to the team. Community-based advocates are also extremely helpful. And so these are people or groups locally who understand your experience and can share wisdom about navigating the special education process. They also may be able to attend meetings with you. And like I said, we're continuing to build a resource on our website, which maps advocates and community groups around the state so that parents can make those connections. And so when you go to our website and scroll down, there's a parent resources section. You can open that up and there is like a map that breaks out the state into regions. And then the counties are identified by region. And then there's some drop-down menus to help you identify resources in your area based on region. Next. And so, of course, very importantly, you should make sure that you are utilizing resources to help you know your rights and your students' rights. One of our anchoring principles at REP is that we put as much information as possible into the hands of students and parents so that you can engage in strong, effective self-advocacy. And if we've worked with a client, we do this as well to prevent them having to come back to us and have the same situation reach a crisis point of needing to take formal action, if possible. In doing that, we believe that strong self-advocates not only improve their individual students' experiences, but also strengthen and improve the education system as a whole for all students. And that helps us to move toward achieving our goal of larger impact, such as ending the school to prison pipeline, making sure that schools are serving students with disabilities according to their legal obligations. So I'm sharing some education resources here, in addition to the information on REP's website, although we also link to the website there, and you can see the way some of these drop-down menus work, and how you go to an issue, for example, the first one on this list in the left column under our website, the REP website, you would come to a question, do you believe that your student may have a disability? And you can drop down and you can expand that further and find out what your legal rights are, the process by which a student may be referred and evaluated for special education eligibility, and then steps you can take. And steps you can take often includes in our site who you might communicate with, what you might say, and some template examples of how to send that communication, make those requests in writing. I also want to point out that knowing your rights is about definitely knowing what tools are in your toolkit, but also I find that many times it's necessary for us to learn what's possible in order to know what questions we need to be asking. So we have these question drop downs, but also we provide information, as do these other resources, just generally about special education rights, that I think it's very worth perusing. So you get a sense of what the law covers, what obligations and what rights and what procedures the law covers. And that might help you as you have that gut reaction and are trying to figure out what your options are to even form the questions that you need to form in order to create a strategy and attack plan. It's important to know, though, that the law is not the ceiling of what's possible. The law is the floor of what's possible. So that's another reason to engage in school level informal advocacy steps whenever you can. You can ask for more than what the law requires in those conversations and more informal communications with school staff and administrators. You can ask for very individualized, creative steps the school can take to support your student, improve your student's educational access, and increase the likelihood that they can make progress and track that progress. So I want to just point out that once you get to the formal level, the formal complaint level, you are raising claims based on legal violations. And you're asking for remedies at that step as well in those stages, but you are limited to that floor, that legal floor of like, what is the minimum the school should be doing? That's what the law covers. But our children don't just deserve the minimum, they deserve the world, they deserve the universe. So the law is not laying out what your child may need to thrive. The law is laying out the minimum. And so that's another reason to look closely at, what can I do? What sort of informal advocacy steps can I take to try and improve the situation as much as possible? But then, of course, if you can't, you get into the legal realm which has more of a limited horizon and a narrower horizon. Next. When you have concerns, you should also familiarize yourself. Well, when you have specific concerns, I would advise you to search your school's policies, your state policies and procedures based on what your concern is, like literally based on the keywords of your concern, and see, what does the school board policy say about discrimination? What does it say about bullying? What does it say about the special education referral process? What does it say about disagreements? What are my options if I disagree with the IEP team's decision? That is often laid out in these policies and procedures. So on the left, we have a link, review your school district's board policies, to a spreadsheet that we've actually created and linked on our website. And it includes links to all of the 116 school districts in North Carolina's board policies. So we found that it's often frustrating to search around for the board policies. And so we've just done that work for you to cut out that process and, given you those direct links. Next. So I'm going to sum up this slide, basically the message of this slide, by just with the 3 words, communicate in writing. This is so important for several reasons. It's essential because special education laws and policies require parents to send certain requests in writing. Otherwise, the school's legal obligation does not kick in. So when you're requesting a referral for evaluation, when you're requesting records, the school district will have legal obligations to respond in a certain way within a certain time frame, but the law states that you have to request in writing to trigger that obligation. So it's really important that you, as much as possible, communicate in writing to send your requests, but also to raise concerns that you have, to recap conversations that you had in person, just to make sure that you're on the same page with the staff member that you communicated with. This can prevent confusion and miscommunication by putting your understanding of events and agreements in writing. It can also bring staff and administrators attention to your concern. They are dealing with a lot of different students, and just like all of us, when we have multiple things on our desk, so to speak, metaphorically, it helps to have that reminder and that written request so that we can refer back to it, and it'll minimize the chance that it slips through the cracks, basically. And it's not your fault that something would slip through the cracks, but this minimizes the chances that that would happen. It also creates a record of what you've requested, when and how the school has responded, how long it took them to respond, how did they respond. Also, a school should be keeping a record of special education services for your student, their progress. They should have progress reports and teachers' notes. Um, there should be documentation of meetings, meeting decision-making, just like they have records of grades and attendance in the general education realm. So you can request that, and reviewing that information will help you and any advocates working with you, or anyone from the team that you've built who's coming to the meeting with you. It will help you to prepare for the IEP meeting by understanding what's happened and spotting areas of need and understanding what has been tried, and whether or not the school has been really tracking your students' progress, um, without having clear, consistent progress monitoring. How, it's hard to determine that the IEP is appropriate for your student. You got to know how your student's doing with that. So you can request those records ahead of a meeting. You can request to get them ahead of a meeting. I usually will say, can you provide these to me with at least 48 hours before a meeting? They're not required to do that by law. There's not a law that says the school must provide the parent with records within 48 hours or 48 hours before a meeting. However, you do have the legal right to meaningfully participate in educational decision-making, for your student and in IEP meetings. And so this is a way of you being able to meaningfully participate, to be informed, and be able to present your concerns and make recommendations to the team. Next. So I want to note that the special education section of our website goes into all of this advice, and includes also advice on preparing for IEP meetings. It goes into that in great detail. And what I just mentioned here, do you feel like your concerns are not being heard in your child's 504 or IEP team meetings? This dropdown expands on some of what I just said about your right to meaningfully participate, gives you a summary of what the law says, and then steps you can take. And it will include the step of requesting records, reviewing them, tapping an advocate, non-legal advocate, family member, someone to support you in reviewing the information. And also, another recommendation that's worth noting is to send your concerns to the team ahead of time in writing. That's another reason to communicate in writing, and an example of communicating in writing. That'll save you time at the IEP meeting. Your concerns will be in writing. You can refer back to them. People will have already seen them. Your concerns will be more likely to be accurately reported in the meeting paperwork.
Mhm.
IEPs include meeting paperwork will include parent concerns. What did the parent propose anything? Was any proposal made deny, or did the school deny anything? Why? So you can help to make sure that those notes that paperwork, that record is accurate by having sent your concerns ahead of time in writing. Next. Another really important tool related to IEP meetings and IEP disagreements in your toolbox in the informal preventative stage is to request a facilitated IEP meeting. This is a service, facilitated IEP meetings. An IEP facilitator is a service provided by the North Carolina Department of Public Instruction. And DPI, as we call it, is the state agency that is tasked with monitoring school districts' compliance with education laws and policies. And there are links here in this slide to a bit more information about how to request a facilitator, instructions, the form that you need to use. You can basically, an IEP facilitator is a neutral third party. So it's someone who is not connected to the school district. They're not representing the school district. They're not representing you. They're coming in to make sure that the meeting runs smoothly, that there's a clear agenda for the meeting, and that everyone gets a chance to speak, everyone is heard. And if something seems convoluted or confusing, that they can address that and pause and make sure that things have been fully explained during the meeting. So the facilitator, it's important to note that you need to request the facilitator at least 10 days before the meeting. DPI needs a 10-day window to assign someone. Both parties, the parent and the school, must agree to a facilitator. It's very rare. I've actually never heard of an IEP team declining a facilitator, and there may be many reasons for that. Anything from they might also appreciate having a facilitator, especially if communication has gotten tense. Also, it's not a good look to deny a facilitator if there is a disagreement and there's tension and there's a reason that the parent needs to feel heard in the meeting. It can only improve things. And it's a little bit of it's opened the lines of communication to DPI a little bit, that there's an issue here that requires a facilitator to step in and help with facilitating communication. So the facilitator, once one has been assigned, they will contact you and they will contact the school, the IEP team separately, discuss with you concerns and issues. Then they will create that agenda for the meeting, and that's what you'll follow at the meeting. So this is helpful, of course, if, like I said, communication has grown tense because of disagreement, or if you feel like you aren't being heard or adequately acknowledged when raising concerns and your concerns really haven't been addressed. Next. You can also request mediation, again through DPI, even if you have not yet filed a formal complaint against the school district. So you can also, this is before filing a complaint. You, of course, can also mediate after filing a complaint. So how do you know whether to file a complaint or not before mediation? How do you know whether it's right to request mediation or to immediately file a complaint and then try to mediate your claims? It's really all about the statute of limitations. We'll talk a bit more in a little bit about the 3 types of formal complaints for special education claims that there are. You must file within the statute of limitations for your claims in any forum in order not to lose the ability to raise those claims. And so I'll just highlight here, but again, we'll talk about it more later. The 3 forums that we're going to discuss range between a 180-day statute of limitations or a 365-day statute of limitations. And that depends on the type of complaint. So hold that thought and just consider this blue box a reminder when you refer back through these slides. We're also going to talk through remedies a bit later. In mediation, DPI will assign a mediator after you've gone through the process of requesting, but the parties will control the mediation and negotiate a resolution. So this can result in a settlement agreement, including steps that you and the district agree on to address your concerns. And so, like I said, we'll get more into remedies a bit later, but that's what you would agree on. The steps to remedy the harm to your student caused by the school's actions or inactions related to special education issues. Next. So let's think through a hypothetical to practice spotting issues and developing a strategy for how to address concerns and disagreements with the school. I'm going to read the hypo facts, and then I think, Emily, tell me what you think. I think a good way to do this would be to read through the questions one by one and have people offer answers in the chat, and I can kind of look at what people are saying, call out, what some common answers are or interesting answers. And then I'll talk through some of my ideas about how to approach the situation.
That sounds great. Thank you.
Okay. So the hypothetical is for a student named Angel. Angel is an 8-year-old fifth grader with autism who has received supports via an IEP since she was in kindergarten. She's incredibly bright, but struggles with sensory triggers. Her teacher reports that she is regularly disruptive to the class because she won't sit still during instruction and has multiple meltdowns per week. You were told by your child's case manager that if Angel can't get her behavior under control, the IEP team will need to meet to discuss putting Angel in a separate classroom or school setting. So, based on what you may already know and based on what we've covered, I'll go through these questions. And let me just open the chat as well. What do your instincts say about this situation, about what's going on? Yeah, there's more to behavior than just, you know, there's more to the child's behavior than just the impact that she's not, or the end result that she's not sitting still, and that's a problem. So yeah, requesting that an expert observe and help interpret what's going on. Yeah, is her IEP adequate? Maybe something more or different could happen with her IEP. So the school has come to you and said, if this doesn't, if she doesn't get this under control, we're going to remove her. Well, maybe there's something else that they could be doing. Now, if you've reached out and let's say you've requested an IEP meeting to address whether or not she's being supported, and yeah, as Whitney said, examining some of the classroom environmental factors, doing an observation, getting an expert opinion, and maybe looking to see how the IEP could be amended or updated. Who would you want to bring into the team? Who would you want to bring into that discussion? An OT? Yeah. That would depend on financial ability, absolutely, as far as an outside person. But as far as the school team, who would you want to bring? Like, let's say, yes, let's say either through insurance, you have services outside through of occupational therapy, or let's say maybe her IEP already has some behavioral goals, or sometimes they're called social skills goals, or she might have related services. She might have an in-school OT. Maybe that person could have some input. Maybe there need to be some changes. Maybe she needs that. The classroom teacher absolutely can be brought into that discussion, even if she's the one kind of treating it like bad behavior. Having a fuller discussion with that person could help open the conversation about what is this behavior, what's being communicated with the behavior, what does Angel need? Where can you go to learn more about your rights and Angel's rights? Yep, you can go to our website. You can go to some of those other resources as well. Rights Law, Disability Rights North Carolina, Duke Law Children's Clinic has an incredible resource called The Parent's Guide to Special Education in North Carolina that we've also linked to. Looking at the NC policies for children with disabilities. A teacher the student talks about as her favorite teacher, a trusted adult, someone who this student has connected with, who is connected with this student. They will have great input on the student. And maybe that's something that you talk about with the IEP team. Maybe your student would benefit from more interactions with that person that they have a good relationship with, that they feel comfortable with. Where can you go to learn more about the procedures? I kind of gave that away. I said the policies, but I would expand that, in addition to the state policies, what other policies might you look at? Yeah, a behavior agency. Sometimes districts contract with outside behavior agencies, and you can ask them, do you contract with, especially this is a student with autism, do you, or for any student whose behavior needs more observation and analysis and parsing, does the district contract with outside clinics, with experts in behavioral analysis? Is there a behavior expert at the district level who can come in and talk to the school team? Autism Association. I would look, yes, and I would look at school board policies as far as the policy, as far as understanding procedures. I would look at the school board policies as well as state laws and policies. What requests would you put into writing? Given what we've talked about, so maybe her IEP isn't serving her, or maybe someone needs to observe, what requests would you put into writing? Yeah, requesting an IEP team meeting. You might think to yourself, she doesn't have behavior goals. We need to assess her behavior. I would like to request an evaluation or an assessment. Yeah, look at the observational data. Yeah, make sure that the observational data is robust. Now, let's say the school took a couple notes one day, all in one class in one scenario. And so they didn't record observations of some of the behaviors that have been issues for Angel. And so you might come back to the team and say, I want to make sure that these other behaviors are included and observed and discussed. Yes, so to understand the process they went through to make the decision to put her in a special environment. And so I'll come back to that in 1 second, but for the last one is, how could you utilize mediation here? And actually, what Megan Amal just said can be part of that. So she hasn't been moved yet, but they're basically saying to you, if she doesn't on her own change this without us taking actions, not in all those words, but if she doesn't change this, if this doesn't change, we're going to put her into a separate classroom or school setting. So as Megan and Amal point out, you want to understand that process, but you're disagreeing with that process, maybe. And so how could you utilize mediation here? Mm-hmm. Yeah, Whitney makes a good point about understanding what's going on in the setting, understanding more specifically what's leading to overstimulation, if that's the cause. Observing that so that you can not only include behavior goals or perhaps create a behavior intervention plan, but also look at the accommodations in the IEP, such as seating, breaks, pairing with a peer buddy. So we could go to the next slide. So we've gone through some of my thoughts on these. I want to point out kind of what Megan Amal pointed out, which is that, Angel, she may not be getting what she needs in that setting. She may need something different. She may need something different in her IEP. Why does the school think that she cannot be served or she cannot participate in that, let's say, gen ed classroom? Because she's in a gen ed classroom right now. This goes straight to her right under federal law, under the Individuals with Disabilities Education Act, to be educated in the least restrictive environment to the greatest extent possible with appropriate supports and services. And so an environment is not necessarily a place, a room, or a school, but it is the amount of time that a student with disabilities spends with non-disabled peers in the general education setting. And by law, in order to be serving a student in the least restrictive environment as determined individually for that student, the school must try to the greatest extent possible to serve a student with appropriate supports and services in a less restrictive setting before determining that they can't help that student remain in the setting. They can't support that student there. Collect that data to show that it didn't work before changing the student's placement. So in this case, mediation could prevent that from happening. At this stage, no change of placement has taken place. And so mediation could help prevent the harm to Angel that you think would come from an inappropriate change in placement. And if it's important to note here, and we'll talk about this a little bit more when we talk about formal complaints, but if the school has not actually changed Angel's placement yet, and you disagree with that change, then a formal complaint specifically may not be appropriate for you, because it may not be relevant to you yet, compared to a situation where the school just declares that they're changing her placement. Say you're in the IEP meeting, they're like, we're changing the student's placement. You've disagreed. They're like, we're doing it anyways. We don't think it's appropriate. She's disruptive. The decision has been made. At that point, you may be in formal complaint territory. There may be a harm that has happened, and you may want to prevent the school from following through with that decision. So we'll talk a little bit more about that in a second. Next. So now we'll move on to formal complaints. Next. When informal advocacy with the school has not been successful, you may want to pursue a complaint or a grievance to make your voice heard. And so in this chart, we're laying out the types of formal complaints you can use. There are complaints at the district level. So in the white cells, you'll see grievance and complaint, suspension appeal, Title IX complaints, school-based 504 grievances. If you do not have an IEP, but your student has a 504 plan. Those are all formal, but they're at the district level, and you're going to want to refer to your district board policies to see the procedures and timelines for those complaints. But generally, they vary a little bit between districts, but there's a general time frame that schools stick to, that districts stick to. And so they may vary slightly, but in this time frame column, we give you generally the time frame that you'll need to file a grievance or a school-based complaint based on when the incident happened, when the decision was made, or, let's say it's a bullying complaint, when the bullying happened, or when you became aware of the bullying. That's when the clock starts. And so school-based grievance is something that you use to address a final administrative decision. So if the principal has declared a final decision as far as your student's schedule, or some aspect of your student's experience in school, or if they have decide, like, let's say to go back to bullying, because I'm trying to go to things that don't represent clear legal violations. So a formal complaint outside of the school district may not be appropriate when something is not actually a violation of the law, but you still disagree with it. You can still complain about it within the school district. You can still file a grievance if it was a final administrative decision. So let's say in the world of bullying, if you make a complaint and you don't agree with the decision that the school comes back to you with, that's considered a final administrative decision, and you could file a grievance on that. And that would raise it up the chain in the district of who would investigate, who would respond to your complaint, and what process they would need to use. And so the same with the school-based complaint, except the school-based complaint doesn't have to be a final administrative decision. It's just a decision that has been made. It might be a decision that a teacher made or other staff, but it wasn't a final decision, but you still want to challenge it. And maybe it's not a legal violation, but you feel it's affecting your students' experience in school in a way that you don't agree with and you don't want. So I'll go through the outside forums in more detail for the rest of the presentation, but you can see an overview of these outside formal complaints in the yellow portion, in the yellow cells in this chart. Please note the statute of limitations in the time frame column. For those complaints, this is where we have the difference between 180 days and 365 days. Also, these forums differ by the types of claims they'll hear or investigate. They vary slightly. The types of remedies that they may order, and how accessible they are to parents who are filing pro se, meaning without legal representation. Next. By the way, I want to note too, I see that people are dropping some things in the chat. That's great. And I'm hoping to pause for Q&A after. And so we'll take, I'm sure, questions from the chat, right, Emily? Okay. So again, I want to refer you back to our website, but specifically regarding the school-based, it's a school-based grievance, but also school-based grievances and school-based complaints. So you can locate your school board policies through the spreadsheet that's linked on our website. And also you can find tips within the issue areas on our website for filing school-based complaints and grievances. There's a section too on our website called complaints and grievances. And it's within that section that you can find the link to school board policies, to that spreadsheet. And also you can find templates to use for filing like a grievance, a school-based grievance or a school-based complaint. Next. So now I'll focus on the 3 outside forums for formal complaints that were the last 3 rows, the yellow rows on that chart. Next. So these are the 3 types expanded a bit more in more detail. So this is if you have not been able to resolve your concern informally. You've tried and you failed. Maybe you tried to mediate, but you weren't able to resolve pre-complaint mediation. And you can, if you've initiated a pre-complaint mediation, a mediation through DPI, and you cannot come to a resolution that you're comfortable with, you can pull out of that mediation. You don't have to settle through that negotiation. You can pull out, and then maybe you decide that you want to file a complaint. So the first type that I've listed here is the state complaint. A formal state complaint is filed with the North Carolina Department of Public Instruction. And we have some general information, which I'll return to in a second. Then there's the discrimination complaint with the U.S. Department of Education's Office for Civil Rights. So it's called a discrimination complaint because that is the framework for special education claims to OCR. OCR investigates claims of violations of students' rights under Section 504. So the student has been denied access to education equal to that of non-disabled peers, which is a form of discrimination. And Title II of the ADA, which is, there are several layers to Title II, but it's the OCR is really overseeing the rights of students in public schools because public schools are receiving federal funds. And so under those laws. And so those laws are important, as well as some laws that we haven't mentioned here. Title VI of the Civil Rights Act of 1964 also notes that there should not, schools cannot discriminate against a protected class, which includes, race, ethnicity, national origin, sex, disability. There's the contested case petition. And that is a claim that you would file with the North Carolina. It's also called a due process petition. So I'll refer to it mostly as a due process petition. And you file that with the North Carolina Office of Administrative Hearings. Now, it may seem like I'm jumping from state forum to federal forum back to state forum, which I am, but there's a reason for that. I want to group the DPI state complaints and OCR complaint options in your mind as forums because they are both very accessible to parents filing pro se. You do not need an attorney to file a complaint with DPI or with OCR. They have forms that you can easily fill out online. There are very clear instructions for filing. You fill out the forms with the facts of what happened, what you disagree with, what went wrong, how the school either acted inappropriately or failed to act. You can include a description, you should include a description of what harm you think your student, how your student was harmed due to the school's action or inaction. And you'd list the actions that you want the school to take to remedy the situation. And again, we'll talk about remedies more in depth later. But basically, it's a fact-based process. You are supplying facts, and it's helpful to know your rights. It's helpful to become familiar with the laws. And in perusing Know Your Rights resources that I've linked, but you are not required to say this specific law or this specific provision was violated. The Office for Civil Rights and the Department of Public Instruction do not expect you to be experts on the law. However, the Office of Administrative Hearings is very different. And before I move on to that, well, while I'm on that train of thought, the Office of Administrative Hearings is very different in that you do need to be an expert on the law. You do need to raise a specific legal violation claim so that you don't lose that claim. Again, I want to highlight the statute of limitations, but also in the case of state complaint and OCR complaint, there's a pretty clear timeline for investigation of a state complaint. So in both of these cases, you're filing a complaint. An investigator will reach out to you to start the process of reviewing your complaint, deciding whether to investigate it, and then would conduct any investigation. And for a state complaint, that whole process, after they've opened the investigation process and just coming to a decision, ordering any remedies, that would take 60 days. They have a 60-day timeline for that. If it needs to be extended, there's a process by which a party can extend it, request an extension, but that's the timeline, 60 days. Now, an OCR complaint may take longer. It can take anywhere from 3 months to years. More likely not years and years, but that does happen. There are many reasons. There are many factors that this depends on, the OCR timeline depends on, some of which are opaque even to us after our, even with our experience of filing OCR complaints. The timeline can change due to like the time of year that you file your complaint, because maybe the OCR investigators are all at their year end. And so they're closing all their complaints and they're not going to get to the new complaints yet because they have to meet that deadline. Maybe they're just at capacity because so many complaints have been filed. And so you are in the queue to be reviewed, even the review stage, to determine whether or not your complaint will be open for investigation. So that timeline is a little more gray. It could take longer. It'll take longer than 60 days anyway, most likely. So getting back to due process and why it's very different. It kicks off a very different process. And it's much more like formal litigation. And so I'm going to talk a little bit more about all these specific types of complaints in the following slides. I want to point out in this slide, and we'll review and recap this a little bit later, but the general information here introduces the differences and factors that you might consider when trying to determine which forum is appropriate for you, and whether or not you want to consult an attorney to determine whether due process is appropriate. So we've got the statute of limitation, the specific laws that the forum will review and investigate. DPI investigates, you can raise violations of IDEA. So the Individuals with Disabilities Education Act, that's IEP land. Special education law that requires a school to provide free and appropriate public education, FAPE, which is access to education and the opportunity to make meaningful progress towards graduation, having the disability-related needs of a student met with an individualized special education plan, their IEP. DPI will not hear violations of federal law, and OCR will not hear IDEA violations, with some nuances, getting a little bit into the weeds, but like if procedural violations like the school never did not hold an annual review, or they haven't evaluated your student in the past 5 years, even though they're supposed to reevaluate every 3 years, that type of procedural violation, OCR may investigate that, but I would urge you not to consider OCR as a forum to raise IDEA complaints or IEP related complaints. That does not mean that a student with an IEP would not have claims appropriate for OCR, because of the discrimination aspect of the federal law that applies to students with disabilities in public schools and schools receiving federal funding. So the Office of Administrative Hearings, like I said, it's much more like formal litigation. Another thing that differentiates OAH complaints, which we'll talk about a bit more, is the timeline. So the timeline of when you need to file, the timeline to a hearing, if there's a hearing, which can be 4 to 6 months, the process of requesting mediation or trying to settle. Only OAH will only hear individual claims, whereas the other two forums, so claims about harm to an individual student, whereas the other two forums will hear what are called systemic claims, if you are arguing that multiple students were harmed by the same practice or policy as your student, and you want there to be a systemic change, and so you're asking for a remedy to affect multiple students. That's a more appropriate claim for DPI or OCR. And again, these are links that you'll get a chance to peruse that have take you directly to either DPI's website or OCR's website, or more information through various resources about the process of filing. If there's a form that's relevant to you, giving you links to those forms. Next. So I want to talk a little bit about remedies. And by the way, we have about 5 more slides, which some of them do not take a lot of explanation. How's everyone doing on time? Good, okay. So this is a little bit more detail on remedies, which I've continued to promise we would get to. This is what you can ask for in formal complaints or mediation. So remedies available can differ, like I said, between the outside forums as far as what they can grant, what they will grant. And that can help you determine which forum is appropriate for your claims. So like I said, there's the individual versus systemic. Like OAH will not hear systemic claims, so they will obviously not grant systemic remedies. So to differentiate between the two types, individual remedies repair the harm to your student. And so this is a way to get, like, for example, how to get them on grade level, or for, in the example of reading skills, um, maybe a more appropriate way to gauge progress, and to craft a remedy would be based on individual reading skills. So maybe you're saying they should be, rather than totality of grade level, maybe they're an older student who is still struggling with the fundamental components of literacy. Maybe you want to gauge progress on individual reading skills based on benchmarks of a reading program, that is appropriate for students with disabilities affecting reading. A systemic remedies would have broader impact, like I said, on students in the school and district. Um, a thing to note for systemic remedies. So there have been OAH cases that have ordered, like, for example, a case I can think of is a student with disabilities affecting reading was put in a separate classroom, and that classroom teacher, that EC teacher, was not using a reading program. The school district only had one reading program for everyone, and it did not have um, material appropriate for students with literacy disabilities, appropriate for remediation. And so the OAH complaint resulted in a remedy of the district adopting a remediative reading program. Now, that obviously affected more students than just that individual student, yet it addressed that student's individual harm. It was a remedy pled to repair the harm to that individual student caused by the individual impact of a legal violation. Now, if you are arguing that all quote unquote similarly situated students have been harmed, and so the remedy must address all of their harms, that is just squarely going to be something that OCR will not grant. They will not hear that claim, and they will not grant that remedy. So I just highlight that because there are, when you bring a formal complaint, you are impacting more than just your student, most likely. You're improving the situation for more than just your student. However, claiming specifically that, like, all students with reading disabilities in this district are harmed, and so this reading program must be used with everyone, spelling it out like that, that's gonna be something that OAH, the Office of Administrative Hearings, will not investigate or grant. Next. So the next couple of slides are going to be examples of DPI and OCR complaint forms. So this is the DPI state complaint template. This is a form that's available through the link that was in the chart that we looked at earlier. And that link also directs you to information about the full procedures for filing, instructions for filing. And it's really important to review those instructions because you need to fill your complaint out in a certain way, send it to certain people. You can either email it or you can send it through regular mail, but it's important to familiarize yourself with those procedures because those are unique to state complaints and they're going to be different for OCR. And so you can see here, it's pretty, I mean, this is the whole template. You're putting in name, information, what happened, what was the harm, like, what are you asking for to remedy the situation? If you have more to say than you can fit in here, you can write it on another piece of paper, you can continue it on another piece of paper and just say, see attached, but this is the format that you're following. Next. And so this obviously is the template for an OCR complaint. And this is accessible through their website. This is a form that you fill out within the website and you can submit it online. You literally click through the form, the pages. There are many more pages than this, but this is basically what they look like. This is a good example of what you're doing when you're clicking these boxes. And then there's areas where you can fill in detail and provide your narrative of what happened. And OCR has such detailed information about how to file a discrimination complaint for special education. They have instructions in writing. They also have like a video, which is a very helpful tutorial just to walk you through the process for a few minutes with different people talking through the process and providing visuals and examples. It's very clear. Next. So this is where I've gone into a little bit more about the due process complaint and just some reminders. So there is a contested case petition form that is available on the Office of Administrative Hearings website. But again, I do not recommend that you just go on there and fill that out and file it pro se without at least getting legal advice from an attorney, at best being represented by an attorney if through that advice you learn that you have strong claims for a due process complaint. So we highly recommend, not only because of the process that you can trigger of that's very much like litigation, you know, with discovery and motions that you need to file, and there may be testimony. In order to prove your case, you may need to have an expert witness to explain why the quality of services, which an OAH claim is the Office of Administrative Hearing will hear more a claim about quality of services, the substance of the decisions that an IEP team makes, whereas, and evaluate, were they appropriate? Did they really provide the student with what they needed based on the student's needs, according to expert opinion, to provide the student with FAPE? That requires expert opinions, expert witnesses, detailed evidence of your student's needs and why that student needed something specifically different in order to access education. Whereas DPI and OCR, they're giving more deference to the school teams. So you can, and we do argue there have been substantive inadequacies to the services that the student has been provided, but there's a lot of deference by DPI and OCR to, like, did the school do their legal minimum obligation? Did they consider all the information? Did they come to an informed decision? They're less likely to question the decision that the team came to. Whereas in OAH, you're building out a fuller case with more time and resources to show that the actual decision the team came to was not appropriate. It was not enough. They needed something different. So again, not as accessible to parents filing alone. And I've said this before, but I want to give a specific example, anonymously, of course, but I had a case where a grandfather who had been engaging in heroic advocacy for his grandson for years had filed a due process contested case petition on his own and came to us, and we helped him to withdraw it. You can withdraw your petition while still preserving the right to refile your claims. It's a specific type of withdrawal, but we advised him to do that because he had kind of written a fact narrative, but he really hadn't anchored his claims legally, and he was in danger of presenting a very weak case, of losing his claims, losing the opportunity to bring the full claims that he could have brought. But also, having filed by himself and then having to withdraw, that complicated his ability to find an attorney to represent him in a new due process case, because some attorneys will not take a client for due process if that person has already filed pro se, even if they've withdrawn in a way that preserves their right to file claims again later. It kind of pollutes your chances of potentially of finding representation from a private attorney. And then again, then I've linked more information. So the Parent's Guide to Special Education in North Carolina, that's the Duke guide that I referred to that I highly recommend you check out the index, check out the different sections. Page 73 goes into detail about due process complaints. And the UNC School of Government also provides an overview of, with some like citations to law, talking about process and procedure, and how that whole process works, how a due process complaint works, and how a hearing might work if you go to hearing. Next. So I want to recap a little bit where we've been before we open it for questions. And this, I hope this provides kind of a condensed sense of what you can find, like what information you can find and what links to further resources you can find and where. We looked at our online resources, talked about building your team, the steps to prevent crisis, the importance of communicating and writing, reviewing, knowing where to find board policies, state law and policies, understanding mediation opportunities before filing a formal complaint or after. I didn't talk as much about mediation in the formal complaint section, but of course, after you file a formal complaint, there is the option to mediate. You could come to a settlement agreement. The process for requesting mediation is slightly different in the different forums. It's another reason to go to the links that I included in those charts for like a state complaint, OCR complaint, to understand like what is the process for filing, and then at what point can I request mediation? And there are different options. You can have that forum appoint a mediator. You could engage in just party to party negotiations without a formal, like without an appointed mediator. You can come to a settlement agreement. You can decide you want to pull out of mediation and proceed with your formal complaint because you were not able to resolve your concerns through mediation. That's also an option after formal complaint. We talked a little bit about the school-based formal complaints, and then we talked about the 3 forums. And we talked a bit about remedies. So I want to open it to questions. Thank you for bearing with me for those extra few minutes. Let's see. And Emily, thank you so much for sharing your screen.
No, thank you. This worked out great.
Let's see. So there are a lot of great comments being dropped in here about the hypo. Is there a way to share this out? If you're asking about, can we share out the slides, we will absolutely share those. I have sent those to Emily and we'll make sure that they're all navigable and you can receive those and just use them and refer back to them. That's a resource for you that you can use from now on. Is there a timeline for OCR complaints? That might have been before we talked about that. When the school doesn't have the personnel to help with the IEP solutions. And so tell me a little bit more about that. I have some thoughts immediately, but do you mean they don't have, like they're short-staffed and so they don't have like a therapist or they don't have like an EC teacher? Is that what you mean, Jay? Yeah. Okay, so it's a reality. School districts are short-staffed. There's high turnover and there are not enough staff on hand to conduct observations, do evaluations in a timely manner within the 90 days required by law after you've made a written referral for evaluation. If the school takes longer because of short staffing, or if the school tells you, well, we can't provide a one-on-one because we don't have staff for that, or, well, we have to do pull out and put them in this small classroom because we don't have someone who can push in to help them with reading in the general ed classroom. That is unfortunate. It's a reality. It is not, for lack of a better phrase, it's not your problem, and it does not excuse. It's not that it's not your problem. You are experiencing the short staffing repercussions, but it does not absolve or excuse legal violations. So most fundamentally and generally, a school's obligation to provide individualized services tailored to meet a student's needs so that that student can receive a free and appropriate public education, which is defined by the law as providing that student with the opportunity to make meaningful progress uh, towards graduation and on their IEP goals. And so you have a plan. They need to be able to make progress. The school needs to be monitoring that progress. The school, as far as the least restrictive environment, so the IDEA, the fundamental buckets of rights are FAPE, free and appropriate public education, in the least restrictive environment. We talked about LRE earlier. Um, the school needs to be providing the full continuum of placement options. And if they're telling you that they can't provide something to help your students stay in the general education setting, or they're too short staffed to be able to fully provide LRE and try services and supports before moving your student to a more restrictive environment, for example, then they're not providing the full continuum of placement options. If they can't serve your student, they need to, you can discuss with them, is there another school in the district that you can place my school at that can provide them with the services and supports that afford FAPE to my student in the least restrictive environment. And that is a situation that can give rise to, you can go through the informal dispute resolution processes. That's, you might, elevate your concerns to the district level, contact the EC director, and ask them to get involved and review the capacity to provide certain services to your student in the school environment, or whether there's another school in the district that could better serve your student. And if you cannot solve the situation there, then you could file a formal complaint, because regardless of the reason, your student is not being afforded FAPE in the LRE. So there's a FAPE violation. But also, if the school is telling you, we cannot provide your student with a one-on-one because we're short-staffed, that's not, that's more of an individual, that gives rise to more of an individual claim. But there's a little bit of a question, like, so you can't provide anyone with one-on-one. Sometimes we have situations where a school has told orally or put in writing, maybe it's in meeting paperwork, in the meeting minutes, the school actually, someone in the IEP team said, we don't do that because we don't do that here. Oh, we don't do special seating in this class because the teacher gets to decide where the students sits, or we can't provide one-on-one to students because we don't have staff in this school to provide one-on-one to students. That's the type of language that you could use to show a systemic complaint. Similarly situated students would be harmed by that. It's more than just your student in that case. So the school boards, do they interpret? It's not that they're like the final official, they don't provide like the official interpretation of laws and regulations, but they do hear appeals, and a complaint being appealed through the district may get to the board, and then you'll have a hearing before a board panel, or appeal hearing before a board panel, and they will be, making a decision based on their interpretation of laws and regulations and policies. You may decide that they've made an incorrect interpretation. You may decide that you want to appeal further, but so I hope that answers the question. Are there any other questions? And I realize that I've gone through a lot of information, and you may, like I said, the questions may crystallize later. So hopefully looking back at these slides and looking at the resources that we've linked will help you in that process. Can individuals access research within DPI? Well, talk to me a little bit about what research. So DPI has a lot of information on their website. They have, which includes like reports on different topics and issues. Like they'll have annual reports. They might have materials that they've compiled based on dropout levels, dyslexia remediation. So there is information online about, what services are available to address different needs. Dropout levels are more, you're going to get that type of information. Well, you can get that type of information, first of all, through advocacy groups. DPI will be reporting, and the State Board of Education will be reporting statistics that will be in what's called the state report card, the school report card. So there is a state report card based on data it's usually within like a year and a half old. It's pretty current. And you can look at the district level, even at the school level, and see rates of different academic performance broken down by identity groups, subgroups. You can see rates of discipline, rates of long-term suspension, rates of expulsion, rates of graduation, based on total numbers or based on breakdowns of race, gender, disability, income need, financial need. And I can send that link along as well to Emily so that we can share that with you all.
Great, thank you. Rebecca, I had two questions, if there's time, real quick. I was just
Yeah.
thinking about families that have come to Decoding Dyslexia recently with questions. And let's see. So obviously, facilitated IEP applies to families, students who have an IEP. What about a family who has reached a wall at the referral process or the eligibility meeting process? So they are not moving ahead with an IEP because they've hit that wall at eligibility or referral. Would they be able to request mediation, or would that not be allowed in that situation?
They could request mediation, and they could also reach out to district level staff to get involved. You could reach out to EC director. I would advise someone who has made a referral and gets to the referral meeting and the school team says, we don't see a reason to evaluate. We just don't think this student is eligible. I would recommend that parent or guardian make sure that they have their students' records to understand what information was the district considering when they decided that there's no suspected disability that may be affecting education. Because at the referral level, that's the question. Is there a suspected disability that may be affecting access to education? It's a suspicion that, do we have enough information before us to make a determination at this point? And are they considering multiple sources of information, or are they just considering one? Like, oh, well, this EOG was awesome. They were promoted to the next grade. They're making progress grade to grade. Or are they looking at a range of information for SLD assessment, for example, like suspected disability affecting reading? Are they looking at, have they tried to conduct evidence-based interventions? How has the student done on those? How are their grades? How are their EOGs? What are their teachers reporting? There needs to be multiple sources of information looked at, and you should be familiar with what those sources are so that you can decide whether or not you agree with that decision. if you decide that the school has not reviewed all the information before them or has misinterpreted the information before them, I would definitely recommend that you reach out to the EC director before taking other steps, because that can often lead to a very quick resolution or
Mm.
rapid, impactful steps taken at the school level. But even after that, if you feel that the situation hasn't been resolved, if you feel that the student should have been evaluated in other categories but the school of eligibility, but the school team rejected that, then you may be in mediation land. You may want to consider a mediation to discuss that further.
Right. That's helpful. And one last question along those same lines. So maybe the family went to the referral meeting or the eligibility meeting and things were shut down. Either we're not going to evaluate further or we did evaluate. We don't see a need for an IEP, special education. Um, Maybe they left the meeting that day and they are realizing, yeah, I'm really unhappy about this. I don't agree with the decisions they came to. Where should they request where should they put in writing that at that point that they are not agreeing with the final decisions that were made?
Definitely first reach out to the EC director, but that would be like if it's not clear to you that there was, if you can't pinpoint a legal violation, or if you don't think that you have strong argument based on the records that you've requested and reviewed, that your student should have gotten an IEP. If you don't feel like you have those things, that might be an internal school complaint to appeal that decision. And you're going to want to look at your school board policies to understand that process. However, if you feel that that decision was wrong because the records before you indicate that your student is struggling, let's say it seems that the school keeps giving general education interventions to your student, and saying, oh, well, they seem to learn during MTSS, but you see that your student is still struggling. There may be a question of like, what interventions are they getting? Are they getting maybe response to intervention screenings that are being misinterpreted as evidence of mastery, but they're still struggling? Are they able to make progress toward grade level, so to speak, and then move out of intervention? Or have they had MTSS to address literacy for years and years? You might have the question in your mind, is the school doing MTSS to avoid giving an eligibility determination, or is it delaying eligibility or specially designed instruction? Do I disagree with the way that the school is interpreting my students' results? Or if let's say this is a really common issue where there's behavioral struggles, social emotional struggles, but the student is continues to be promoted grade to grade, is passing their classes. The school team might say, well, they're doing fine academically, like it's this behavioral issue. Well, you can qualify for specially designed instruction to address social emotional needs. That's part of access to education. Let's say something that I've seen a lot that can be connected to behavior, but I think can and has been in my client situations an indication of a disability related need for, let's say, reading struggles. A student is older and they're making it through, they're passing classes, they're getting low grades. They hate doing homework. They don't finish assignments. They don't try. The IEP team tells them if they just finish this, I know they could do it. When they answer questions, they do it well, but puts his head down, doesn't engage, doesn't finish his homework, doesn't turn in stuff, and that your student is struggling because they don't want to tackle text heavy assignments. They're not sure of themselves. They still have struggles, even though they're, in ninth grade, and it's been years since anyone has addressed learning how to read or helping to remediate their skill deficits, you can push back on that. And that may be that type of evidence. If you can provide that type of evidence, you can use that to support legal claims in a formal complaint. And that can be a complaint that can be filed with DPI because it's related to specially designed instruction, and a need for specially designed instruction for students with disabilities, and it's related to IEP process and IEP team decisions. And even though it is a bit of a substantive call, like interpreting this assessment data, does this student qualify or not, there are procedural elements that will be important to review, in what did the team appropriately review all the information before them? Are they interpreting response to intervention results correctly? So I encourage you to go to the district level first, because you can call in, you can say, like, a first step might be reach out to the EC director and say, I really would like a district level literacy specialist to look at this assessment data and help me talk to the IEP team. You can reach out to DPI and see if they have, DPI, there's a DPI affiliated arm called NC SIP, and they are comprised of regional literacy specialists and math specialists, and they train school districts and staff in teaching methodology and remediation methodology, how to approach students with remediating skill deficits for students with disabilities in literacy and math. And they were like instrumental in letters and the rollout of science of reading training for teachers across the state. And they can help connect with schools if schools reach out to them, and refresh training and help review situations and give input and consult on certain decisions. And you can ask the school to reach out to them or to tap their expertise.
That's great. Thank you very much. Great suggestions. Do you have any other questions for Rebecca?
I want to say I have now gone 40 minutes over, and I thank you so much for sticking with me. I really want to say also, I can't emphasize enough how much I want you to know that I have been in your shoes, and it's just, you've got peak emotional investment and your, peak intellectual investment. You're trying to figure out this puzzle, put the puzzle pieces together. You're trying to advocate for your heart that lives outside your body, your child, and the development of their mind as much as their experience of the world. And I really commend you for going through that advocacy process. And I want you to know that there are a lot of incredibly helpful tools and resources out there. So, and I want to encourage you to, which you've already done by connecting with Decoding Dyslexia and participating in this presentation, to build your community and build your team. That is something that has helped me incredibly so much in my process of advocating for my student. And I've seen that help the parents of our clients time and time again.
Wonderful. Thank you so much, Rebecca, for all your time this evening, and going above and beyond with all this wonderful information. We will have the slides for everyone to access, so they can access all of these wonderful links and resources, as well as the recording of the workshop, so we can watch it for the first time or again to get more information. And again, we thank you greatly for all that you are doing to support students across North Carolina. And we look forward to seeing what else the Right to Education Project has in store for us. So thank you again.
Thank you. I encourage you all to sign up for our newsletter. So I will make sure that Emily can circulate that link because we are developing more resources, especially for parents who would like more information and support and guidance in filing pro se state complaints and OCR complaints, filing without legal representation. And so getting our newsletter will help you know what sources are coming out and when, and what issues we're seeing and what, some other helpful information we share.
Perfect. Well, thank you so much.
Okay.
Thank you, Rebecca. I know this will mean so much to everyone. Yes. And you all have a great evening and a great rest of your week. Thank you.
Good night.
Bye. Good night.